From Washington, D.C., Congressman Mike Johnson. Hey, Mr. Mike, how are you today?
Hey, my friend. Good to hear your voice.
Okay, so you on social media, Facebook last night, let me quote, "No surprise that the liberal Ninth Circuit just upheld the temporary restraining order blocking President Trump's executive order on immigration. As I," meaning you, "have explained in numerous interviews, the Constitution and our federal statutes clearly grant this authority to the president. The White House should appeal immediately." Explain to us why that is within the president's powers and what you think they should and or will do next.
Well, listen, the president has inherent foreign affairs and national security powers under Article 2 of the Constitution, and that has always been a part of our legal tradition. Everybody recognizes that. And then, it was more than 60 years ago, Congress expressly delegated to the president broad discretionary authority on this very issue. So there's this Title 8 U.S.C. Section 1182F. It's been quoted everywhere the last few days. It's very clear. Whenever the president, here's the quote, "finds that the entry of any aliens or any class of aliens into the U.S. would be detrimental to the interest of the U.S., then he has the authority to suspend their entry." That's the authority specifically granted under the law. That is the only legal question that these courts are supposed to be looking at in this legal proceeding, and they've looked right over it to just engage in politics. That's not what the courts are supposed to do.
Now, the Ninth Circuit is, am I correct, not only is it a very liberal circuit court, but is it the most overturned?
The most overturned. Look, I've litigated constitutional law cases out in California and on the West Coast, and every time we were arguing the Constitution out there, we knew we were trudging uphill because the Ninth Circuit is they engage in politics. They make law from the bench, and they've got a bunch of what we call activist judges out there, appointed, many of them by Barack Obama, some by Clinton, and others, and they will engage in politics instead of strictly applying the Constitution. We all know that. They've been overturned in the vast majority of their cases to the Supreme Court. And so this was no big surprise, and it's why I think the White House needs to trudge forward and appeal and get it in the hands of the U.S. Supreme Court.
I was going to say, is that where it's headed next?
Okay.
And what kind of time frame for that?
Speaking of the Supreme Court, let me stack one more on top of this, because I read a couple of columns and heard a couple of folks last night said that if the Trump Department of Justice would take this to the Supreme Court, that even with a 4-4 even number, that it would most likely still come down in the Trump administration's favor. Do you think that?
I believe that even though the court is evenly split right now, 4-4, I believe that the legal issue, the raw legal issue here, is so clear that I think even Justice Sotomayor, Justice Kagan, two of the liberals on the court, one or both of them, I think, or more, would almost have to rule in favor of the administration. Now, they might do it reluctantly, but they will have to do that because, the legal question is so clear. There's no ambiguity about it at all. Does the president have the authority? He absolutely does.
A legal clarification, please, because I know that you as a constitutional lawyer can explain. I was also reading last night that it's Washington. Is the second state involved? Is it Minnesota? I forget. I apologize.
Minnesota. Yeah.
Okay, Washington and Minnesota. And it talked about how those states, if it goes to the Supreme Court, how those states don't have, and they use the term, standing before the court. Explain what that means, because the way I read the article, that would be the deciding factor, that the states don't have standing. What is that?
Right. If I was preparing the brief on behalf of the administration, I would list standing first, and then I would get into the legal argument that you and I were just discussing. Standing is the first hurdle for anyone to take a case into the courts. You have to be a party that is actually and directly affected by the adverse law or whatever it is that you're challenging. And so the argument here is Washington and Minnesota have no direct personal, as a state, they have no direct effect or interest in this. This is a matter of national security. It's larger than any state. It deals with the United States as a whole. And the reason that the White House, the Oval Office, has this discretionary authority granted to them by Congress more than 60 years ago, and again, 6 out of the last 7 presidents have issued very similar orders under similar circumstances, is because those are the persons who are best situated to make this call. They are privy to all the highly classified information. They have all the national security advisors and the top military brass telling them what is going on around the world. All of us can't be privy to all that all the time. Only the commander-in-chief does, and that's why we grant them this authority. That's why this is lawful. And, guys, that's why it's appropriate.
You talk about the presidential authority to do that. There were a lot of folks screaming when President Obama issued executive orders that he doesn't have the authority. It's an overreach. You were one. It was an overreach. So why doesn't Congress pass a law with regard to this and then get it out of the courts? Hey, we passed the law. Here's what we're doing.
Well, we don't have to, because the difference here is that when President Obama, on so many of his executive orders, he was literally making law with the stroke of a pen. And he bragged about it. If you remember back then, he said, I've got a cell phone and a pen. I can do anything I want. That's not the way our system is designed to work. The law is made by the legislative branch, by the Congress. The president is in the executive branch. He can't make law. The executive order is limited to, any executive order is limited to the scope of the authority that is granted to the president either by the Constitution or by a statute. And as we've been discussing, that's exactly what the statute that was passed by Congress here, in this case, has done. So he's not outside the scope of his presidential authority, and that's what makes it lawful and appropriate and necessary. And, guys, Congress could intervene and could tighten up statutes and pass additional ones, but in the meantime, we're in great jeopardy. I mean, we know these 7 nations were already identified by the Obama administration, not by President Trump, by the previous administration, as being hotbeds of terrorism. We know that there are dangerous people aiming to come here, are coming here to do us harm, and we've got to put a stop to it, and that's all this is. It's a pause. It's a common-sense measure to keep the people safe.
What is your hope for the timetable, how quickly the Supreme Court can
And
deal
what
with
is
this?
the next move? Do you think they'll really go to the Supreme Court?
Well, I think there's probably a couple of maybe a dual-pronged approach to this. If I were in the White House advising the president this morning, I would say, Mr. President, let's appeal immediately, and in the meantime, let's revise the executive order. The Ninth Circuit had some rumbling about how they didn't think it was clear. Okay, well, change a couple of words and make it clear, appease them. It's ridiculous. We don't agree with that, but you can moot the case entirely if you just revise it slightly to say it doesn't apply to permanent resident aliens. Do that, reissue the executive order. Let's get about the business of the country, and let's keep the people safe and let the legal system play out as it does.